We are back with another trust and estate quick tip. So today we're going to do a quick comparison of owning property. Let's stick to real estate. So owning real estate with your spouse, and two of the common ways to own it is what's called tenants by the entireties, which is probably the most common way, or joint tenants with rights of survivorship. So both of these forms of ownership will pass a deceased spouse's share over to the surviving spouse. That's the rights of survivorship part. So those two forms of ownership are both very similar in that respect. The couple of big differences between the two: tenants by the entireties ownership structure gives some creditor protection to the property because only your joint creditors can go after it. If you each one of you have an individual creditor, they can't go after that tenants by the entireties property. The other huge difference is severing the joint ownership. If you own something as joint tenants with right of survivorship, whether it's a spouse or a non-spouse, either joint tenant can sell their share to a third party, and that would sever the joint ownership, the rights of survivorship, basically. So if Bob and Sue own a property as joint tenants with right of survivorship, and Bob says, I don't want Sue to get my half when I die, Bob can sell his share to another party, or he can really just, he can gift it, he can do a deed, he can transfer the title in some respects that will immediately change it from joint tenants with right of survivorship to a tenant in common situation, and then there's no more survivorship clause. You cannot do that with tenants by the entireties property. So if you and your spouse own a property as tenants by the entireties, neither one of you can transfer your share to any other party without your spouse's consent. It's an invalid transfer, so you cannot unilaterally sever the tenants by the entireties structure.